Okay, fundamental rights, Article 14 and 15. Right to equality, 14 to 18. Freedom, 19 to 22. Exploitation, 23 24. Freedom of religion, 25 28. Cultural and education rights, 29 30. Right to constitutional remedies, 32 and 226. Okay, Article 14. Equality before law. The state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. When we are using person here, also to non-citizens also. Here, equal protection of the laws means it debars class legislations, means making of improper discrimination by conferring certain privileges upon a class of person arbitrarily select from a huge number of people. The article is available to any person, hence available to citizens as well as foreigners, i.e., equality before law and equal protection of law. EBL, equality before law. Theorized by Dicey, basically all people have to be subject to equal application of the law of land. In the eyes of law, all are treated equal, hence formally equal. It is seen as negative right in nature because nobody is given special privileges. Some exceptions. Article 361, diplomatic immunity, parliamentary privileges, defamation, contempt of court. Here contempt means insult someone in a hateful way. Parliamentary privileges is in Article 105. Equal protection law. Equal protection of laws, EPL. Just because everybody is equal before law doesn't necessarily mean everybody is actually equal. It is considered a positive concept in contrast to EBL that is seen as a negative concept. While EBL is derived from England, EPL is borrowed from US. It simply means that like must be treated alike or law must be equally applied among equals. Thus it gives in effect the substantive notion of equality. For the purpose of equal protection of laws, we need to classify societies and then different treatment can be meted out to different groups. But courts have added the classification of society should be reasonable and not arbitrary. It has given two tests of reasonableness. Firstly, categorized so formed should be a homogeneous unit, means must have common characteristics. Secondly, the classification exercise should have reasonable nexus with the objective to be secured. Nexus means interlinked. Article 15. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. First, the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. But when we here talk about sex, we have women quota in government services of Bihar or special girls schools. What you will say about that? No citizen shall on grounds only of religion, race, caste, sex, place of birth, or any of them be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels and places of public entertainment, or the use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partially out of state funds or dedicated to use of the general public. Nothing in this article shall prevent the state from making any special provision for women and children. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially or educationally backward classes of citizen or for the scheduled castes and the scheduled tribes. State cannot discriminate citizens only on the mentioned grounds. NCRWC recommended the grounds to be expanded based on political opinion, property, and social and ethnic origin. The state can discriminate based on grounds that are mentioned here, e.g., residence. But the states can positively discriminate for women and children. While the first clause provides vertical protection for discrimination, the second clause provides for protection for horizontal discrimination, e.g. of Tamil Nadu restriction to entry to public places based on Dress Codes Act 2014. Is there provision in the Constitution to reserve government jobs for backward caste classes? While Article 16 Clause 4 gives government sanction for reservation for backward classes in government jobs, the Article 29 Clause 2 denies such discrimination in educational institutes. Article 29 Clause 2. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. Means that actually prohibits the state from imposing caste-based quota in state running education. Thus, quota based on this article are prohibited, but since caste-based quotas were available in pre-independence times, they continued after independence as well. But in Champakam, Dorarijan case of 1951, court struck down the quotas based on Article 29 Clause 2. To get around this judgment, the first Constitutional Amendment Act added a Clause 4 to Article 15. Article 15 Clause 4. Nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. Present status of reservation in India: scheduled castes 15%, scheduled tribes 7.5%, OBCs 27%, persons with disability PWD 4%, economic weaker section 10%. Total reservation 63.5%. So as you can see, percentage reserved pie chart is like this. Various state governments have been pressurizing private institutions for reservation. Can the governments impose such reservations? Apex Court in PA Inamdar judgment in 2005, private unaided education institution cannot be forced to have quotas due to Article 14 and Article 19, Clause 1, Clause G. While private enterprises are commercial entities and hence singling out one private sector entity while leaving out others is violation of Article 14, and they also can carry out their occupation due to freedom of profession as seen in Article 9 Clause 1 Clause G. To get around this judgment, 93rd Constitution Amendment Act was passed, wherein Article 15 Clause 5 was added. Article 15 Clause 5. Nothing in this article or in subclause G of Clause 1 of Article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or the scheduled tribes in so far as such special provision relate to their admission to educational institution, including private educational institution, whether aided or unaided by the state, other than the minority educational institution referred to in clause 1 of article 30. While minority institutions were omitted, special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or the scheduled tribes relating to their admission in educational institution can be done only through law. But reservation in government jobs doesn't need a law. They can be brought through an executive order because requirement of law was not present in Article 16 Clause 4. Similarly, while law is required to make provision for backward classes in educational institutions, no such law is required for EWS quota as per Article 15 Clause 5 after the 103rd Constitution Amendment Act. Article 15 Clause 6. Nothing in this article or subclause G of clause 1 of Article 19 or clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any economically weaker section of citizens other than the clauses 4 and 5, and any special provision for the advancement of any economically weaker sections of citizens other than in the classes mentioned in clauses 4 and 5, insofar as such special provision relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in clause 1 of Article 30, which in the case of a reservation would be in addition to the existing reservation and subject to maximum of 10% of the total seats in each category. In 1997, Vishakha versus State of Rajasthan case, the Apex Court laid down the guidelines for protection of women from sexual harassment at workplace. The court said that such harassment of women at workplace leads to violation of Article 14, 15, and 23.